Hey peeps, it's Chris here and with some more lovely random content. This one I thought was pretty important because today's topic is about the copyright system. The copyright system is, well, everywhere and we normally never question it. Imagine your favorite TV show, some random poster you see out in the mall, or perhaps a ttrpg book you own. Every last thing you see in some form is a protected work under copyright law, but they are all used in different ways. So in our lovely video today, I plan to break down how copyright protection changes depending on what media you are coming up with or using. The time frame matters too, but we'll get into that very briefly because it does differ. So first and foremost, we should define what copyright actually is, and go down the list of a few things such as the original works, the copyright owners, what copyright provides, how long it lasts, and of course copyright registration. Now I will say this, before we actually hop in, my primary source for all of this entire section, comes from copyright.gov and can be found directly in the description alongside every other source I'll be using here. I try to be very transparent, and I can get things wrong, so please do forgive me if you see anything that's actually wrong. Of course, correct me down below. So let me hop over to the site. So to define copyright, copyright is a type of intellectual property that protects original works of authorship. As soon as an author fixes the work in a tangible form of expression, in copyright law, there are a lot of different types of works, including paintings, photographs, illustrations, musical compositions, sound recordings, computer programs, books, poems, blog posts, movies, architectural works, plays, and so much more. As you see, there is a lot going on here. This is a big old stew, and oh boy, it can be annoying for some people. I know that much. So let's get into the next portion. Copyright is originally and fixation. I probably said that wrong, but it's okay. Original works. Works are original when they are independently created by a human author and have minimal degree of creativity. Independent creation simply means that you create it yourself without copying. The Supreme Court has said that okay, words. The Supreme Court has said that to be creative, a work must have a spark, an modicum of creativity. There are some things, however, that are not creative, like titles, names, short phrases, and slogans. Familiar symbols or designs, mere variations of a typographic orientation, letterings, or coloring, and mere listings of ingredients or contents. And always keep in mind that copyright protects expression and never ideas, procedures, methods, systems, processes, concepts, principles, or discoveries. Fixed works. A work is fixed when it is captured, either by or under the authority of an author, in a sufficiently permanent medium, such that the work can be perceived, reproduced, or communicated for more than a short time. For example, a work is fixed when you write it down or record it. So an example I will give is, let's say you work on your own, tabletop, and it's all written, everything's done. That is a fixed work. Or if you make a short film, that is also a fixed work. Uh, so who is a copyright owner? That is very simple. Everyone is a copyright owner. Once you create an original work and fix it, like taking a photograph, writing a poem, or a blog, or recording a new song, you are the author and the owner. Companies, organizations, and other people besides the work's creator can also be copyright owners. Copyright law allows ownership through works made for hire, which establishes that works created by an employee within the scope of employment are owned by the employer. The work made for hire doctrine also applies to certain and independent contractor relationships for certain types of commissioned works. Copyright ownership can also come from contracts like assignments or from other types of transfers, like wills and bequests. So what rights does copyright actually provide? So this is actually where everything, is kind of the samey for every category. So let's break down, the bullet points. Reproduce the work in copies or phonorecords. I might have said that wrong, but it's okay. Prepare derivative works based upon the work. Distribute copies or phonorecords of the work to the public by sale or transfer of ownership or by rental, lease, or lending. Perform the work publicly if it is a literary, musical, dramatic, or choreographic work, a pantomime, or a motion picture, or other audiovisual work. Display the work publicly if it is a literary, musical, dramatic, or choreographic work, a pantomime, or a pictorial graphic, or a sculpture work. This right also applies to the visual images of a motion picture or other audiovisual work. Perform the work publicly by means of a digital audio transmission if a work is a sound recording. Copyright also provides the owner of copyright the right to authorize others to exercise these exclusive rights subject to certain statutory limitations. One quick little drink of water. So how long does the copyright actually last for? That's a good question. So the length of copyright protection depends on when a work was created. Under current law, works created on or after January 1st, 1978 have a copyright term of life of the author plus 70 years after the author's death. If a work is a joint work, the term lasts for 70 years after the last surviving author's death. For works made for hire and anonymous or pseudonym works, copyright protection is 95 years from publication or 120 years from creation, whichever is shorter. Works created before 1978 have a different time frame. So I will not be covering much on that part. I will include a link if you want to learn more about works before that, but if I recall correctly, those works, they vary greatly. I do know the typical thing is they get 25 years of protection. I think that's how that works. So let me make sure we have everything here. Okay, so let's go down to what is copyright registration. Copyright exists automatically in an original work of authorship once it is fixed, but a copyright owner can take steps to enhance the protections. The most important step is registering the work. Registering a work is not mandatory, but for U.S. works, registration or refusal is necessary to enforce exclusive rights of copyright through litigation. Timely registration also allows copyright owners to seek certain types of monetary damages and attorney fees. If there is a lawsuit, and also provides a presumption that information on the registration certificate is correct, copyright registration also provides value to the public overall. It facilitates the licensing marketplace by allowing people to find copyright ownership's information, and it provides the public with notice that someone is claiming copyright protection. It also provides a record of this nation's creativity. There's only one place to register claims to copyright in the United States, the Copyright Office. For more information, go see the copyright registration circular, which I'll include down below, of course. So that is only the last thing I was covering from this section of the vid. I just thought it was so important to talk about this stuff because this stuff is super important. So let's get on to my favorite thing, because we've been covering so long on this channel now. Water first. Movies and TV shows. So, movies and TV shows are a damn legal minefield of who the heck owns what. It can get very complicated very fast. So before we hop into the complicated parts, you all should be aware that movies and TV shows, that legally it's known as audiovisual works, and they are unfortunately some of the most annoying and complex copyrighted stuff around. It is so annoying. So how they differ is in the fact that they can include rights to screenplays, music, performances, distribution, and of course the final edit of the show and or movie. This is actually why you often see those massive credits at the end of a movie or even TV show sometimes, which shows the names of basically everybody who's involved and who has or even the businesses as well, who has some form of right in the final product. A rather neat fun fact here is that most film studios are made via films that are from studios. They are made for hire, which means the studio itself owns the copyright and not the director and or actors or actresses involved. It's also why studios can license, stream, or even broadcast their content globally. Otherwise, it'd be a very complicated or hard thing to do for them. They have to contact every single person involved, and it gets very, very all annoying, basically. So now we're done with Hollywood, those dang bloodsuckers. Let's move on to something we all like staring at: paintings and sculptures. So paintings, drawings, and sculptures are all considered works of visual art. The owner... Oh, I almost about to change the image. There we go. So the owner for these things are often rather straightforward. The very moment the artist finishes the work, they own the copyright. but there's also a thing called what's the word? Display rights, which basically says how the art piece is shown to the public. So if a artist decides to lend their art piece to a museum or a gallery or even a gala or something like that, there's a certain things that they have to do to fulfill, their end of the bargain. They want to, display that thing there. Of course, many people do often buy these and give these up anyway, and maybe those places will own those or still want, lending. They still have to display everything the right way. I just want to get that out there. There's something else too. Let's say we refer to a super old artist, like our boy Da Vinci. If you took a super high quality photo of anything he's ever made, it could still be copyrighted. Even if the artist is super dead, and he's been dead for a long time, it's because somebody else now owns that art piece. That's usually how it goes. Now let's go on to something that we all have seen on this channel thus far is magazines. So magazines and newspapers are super unique because they are known as a collective work. Because basically each issue has articles, photos, and of course artwork from numerous people. Each person is referred to as a contributor, and they might own a copyright to their respective piece. So, a section that's in text, an art piece, a photograph, that type of stuff. But meanwhile, the collective work itself, the entire mag or newspaper is owned by a publisher. So let's say ABC owned a newspaper, or better yet, the New York Times. They own everything they publish. Basically, they own their magazine. Just remember, if you ever decide to quote an article or perhaps use a photograph or an art piece, I have to change the image again. Oh boy. Just remember, if you ever decide to quote an article or perhaps use a photograph or an art piece from a magazine, you may need permission from both the author and the publisher of the newspaper or magazine. Now, let's go into a very fun and weird land. ttrpgs. This time I didn't forget. But first order. Lovely. So, tabletop RPGs are protected in a very similar manner to books. So the text, illustrations, and storylines within said RPG is protected, just like anything else, but the game mechanics, how the system itself works, aren't protected by the copyright system. That's very important. But before you get any ideas, you can't just, copy everything word for word. That includes the mechanics. You can't do that, because it's all protected. So the mechanics itself, they can't copyright that. But copying that thing from word for word, you can't do that either. We have tons of D&D bootlegs that are all inspired by the system. The most popular one is Pathfinder, quite literally. But we do have things that that publishers use to handle this through licenses. Also, which the most popular ones that are used today is the Open Game License, which is basically how they basically deal with fan content, be it for free or for money. There's a new one out there now these days called ORC. I don't know what the acronym stands for. I'm sure it stands for Open something. But that's all that's really out there for all this. That's how they all differ. No matter how you twist it, be it a movie, sculpture, magazine, or even a fancy RPG, they all fall under one law. The copyright law, of course. But of course, circumstances change based on the type of work it is. Or, of course, the time it was made. Thank you all for watching. As I said before, links and sources are in the description. Have a good one. See you guys.